supporting terrorism.
This is video taken of the altercation. You can hear the man yelling and see him moving the seaweed used to write Free Gaza. Now, the sisters, who asked not to be identified for safety reasons, are all second-generation Palestinians from Monterey County. They say they were trying to share a message of support for their people amidst the ongoing conflict with Israel. When this man ran up and confronted them, the sisters say things took a scary turn when he noticed their youngest sister, who is only 13 years old, was recording on her cell phone.
So he charged at her from behind with an arm around her neck and an arm around her waist. And he lifted her and shook her until he could get her phone.
And people identified the man as Max Steiner, who ran for Congress in California's 1st District in 2022 and lost. Now, in a statement, Steiner confirms he, quote, trashed the sign, adding he, quote, grabbed their phone and chucked it. Over the course of the day, KION has reached out to Steiner several times for comment, and we have not received a response.
At Tuesday's meeting, supervisors were set to vote on a resolution that would show support for Israel and denounce Hamas.
I'm standing with the resolution and that we should take action today rather than postponing this.
I'm not done, sir.
Yeah, that's your time, though.
Okay, well, please, hopefully, instead of pandering to pro-Zionist lobbies and furthering your political career, you'll do the right thing and worry about things in this community. Thank you.
Thank you, sir. Anyone else? Anyone else in chambers? Then we'll go to those online. Thank you.
I'm going to continue the last part of my Palestinian brother's statement. For those of you that vote in favor of the ceremonial resolution, then you by default support the following. The use of white phosphorus shells and cluster bombs, which are banned by international law on heavily populated civilian areas. The forced depopulation of an area with 1 million people in it and attacking those people fleeing on a route that the Israeli military specified for them. Completely cutting off basic necessities to 2 million non-combatants, basic necessities that were cut on and off for the last 16 years. This is called collective punishment and is against international law. Israeli rhetoric referring to Palestinians as animals. The institutionalized theft of Palestinian land and the creation of Israeli settlements in the pre-1967 West Bank boundaries, again a violation of international law. Palestinian children under 18, some as young as 12 years old, in indefinite administrative detention, the violation of the agreement with the Hashemite Kingdom of Jordan to maintain the status quo of the Al-Aqsa Mosque compound. Most importantly, the possible implications of your resolution were clearly not thought out and are dangerous. Even though this was not an attack on America, Muslims and Arabs are starting to feel it, even locally. A 13-year-old Palestinian girl was physically attacked by a grown man who disagreed with her writing Free Gaza on a sand dune. A 6-year-old Palestinian boy was stabbed over 20 times to death by a landlord, and his mother critically injured over these current events. Girls and women wearing hijab have been verbally abused. There are thousands of Arabs and Muslims that live in Monterey County whom you have automatically marginalized and dismissed with your resolution. Thank you.
Thank you. Anyone else in chambers? See no one else come forward? Then we'll go to those online.
Esther Malkin.
Good afternoon. I wanted to remind everybody that Israel is the only democracy in the region, and that's why the United States supports them and backs them. I also want to remind everybody about the Holocaust, which is exactly what is happening all over again, and we've seen the beginnings of that.
Okay, everyone, we're now going back to item number 3. This is the adopted, we're going to allow public comment just after we make a brief presentation and from initial comments from the board. This is a resolution that came back from last week, initially the titled adopting a resolution expressing solidarity with the people of Israel in light of the recent terrorist attacks on Israeli residents and calling for just and lasting peace in the region for Israelis and Palestinians alike. I wanted to reiterate that most of that resolution language was pulled from the House Resolution 771 that is now co-authored by 98% of all members of the House of Representatives, or 425 out of the 435 members. That includes our local Congress members Zoe Lofgren and Jimmy Panetta, as well as other Democratic Congressmen such as Hakeem Jeffries, Nancy Pelosi, and Robert Lee, in addition to key Republican leaders. Most of our local press failed to mention that clear fact, except I think it was rightly covered in the Carmel Pinecone. We all know that there's not much bipartisanship on anything in Washington these days, but there's certainly overwhelming support across party lines when it came to language of that particular resolution. for the record of the public to know that. And then I want to comment on the most recent changes to this version that I just received this morning. First of all, on the new points that were expanded upon, I do want to say I, of course, support the language denouncing anti-Semitism and anti-Islamophobia and any such actions. Thank you very much, Wilda. Anyone else in chambers? I know we got a few speakers here.
My name is David Norman. I'm a resident of Monterey County. I appreciate the board's efforts to improve the language of its resolution. However, the resolution is still unacceptable for the following reasons and more. Number one, the resolution purports to speak on behalf of all the residents of Monterey County. I'm a resident of Monterey County, and I unequivocally disavow this resolution. I forbid this board to lie about me claiming that I support it. And I can reasonably speak on behalf of all the residents in Monterey County who do not support it when I say that this board may not speak on our behalf or defame us by claiming that we support something which we unequivocally oppose. Two, the resolution further states the Board of Supervisors on behalf of Monterey County and all the residents thereof demands the immediate release of hostages. The resolution cannot pass because such a demand is unconstitutional. Under Article 1, Section 10 of the U.S. Constitution, the Supremacy Clause, and various examples of Supreme Court case laws such as Jering v. Miller, the field of foreign affairs has been preempted by the federal government and the states may not engage in it. This includes the sub-level governments of the states such as the county. In Zering, the Supreme Court outlined a constitutional principle called the Dormant Foreign Affairs Doctrine or Foreign Affairs Field Preemption, which limits the state's power to act in foreign affairs. In Zering, the law in question did not conflict with any foreign policy, federal policy, but even with no such conflict, the court still held that a state may not intrude into the broader field of foreign affairs that the Constitution entrusts to the federal government. The same logic would apply here. Perhaps most importantly, the Jewish and Islamic communities in Monterey County have discussed this resolution and agreed that it is unacceptable in both its forms. We are in agreement that Monterey County should just stay out of this conflict and that no resolution is necessary. We don't want it. Therefore, the entire resolution is inappropriate, unconstitutional, and should be abandoned as of this meeting. And as to point number 3, the basic point here is that the resolution is divisive. Our communities are at peace, and we don't want to bring this conflict here. And again, it's none of this board's business. Thank you.
Thank you very much.
On July 5th, 2022, California Judge Timothy P. Roberts ordered a father to cease praying, and based on the father's admission that he had prayed in view of his son, the judge removed the 4-year-old child from his father's custody.
Because it shows me your decision-making process, which ties in with what you said earlier, which is who is really going to, of two parents, be the parent that promotes the co-parenting, that promotes the visitation, etc. You have shown me that you really don't care about what the court order is. You've articulated that you don't believe that it should be in place. You've articulated that you say you're going to follow it, but you don't really follow it. For example, when you said, I took my son to essentially to prayer with me on multiple occasions, and he did not participate because the court order says I'm not to allow him to participate in a religious activity, I'm paraphrasing, essentially without permission of law, and we were supposed to work on it ahead of time to decide about that. It's one of the legal issues.
You think I'm just using manipulative language to get around?
So when you parse out the word participate and you put your own definition on it, you have a vision of what that means.
You know how complicated the Islamic prayer is? A 4-year-old can't do it.
If you interrupt me again, I'm just going to have to stop. I'm trying to explain to you why I base my ruling on.
I really appreciate that.
So when you take a child to a religious ceremony, they are, in fact, in my mind, participating in the religious ceremony. Whether they sit there and passively listen, whether you talk to them about it or not. So the issue is not can he go to the mosque and can he be instructed on Islam versus Christianity or any other faith. The issue is, I'm sorry, I can't hear you.
So I wasn't talking to you.
You were, in fact, you did say something.
I was saying a little prayer.
So this is not the place to do that either. If you could refrain from that, I'd appreciate it. So the court's orders are basically that I disagree with your vision of what you did.
A question, Your Honor.
Yes.
What if I take my son with me to the mosque?
Well, Mr. Norman, considering what we just talked about, what do you think would happen? I'm assuming, and I'm perhaps wrong, that you're saying unilaterally without permission of it.
Yeah. It's the free. If I freely practice my religion during my custody time, and my son is with me, I don't know if you know anything about Islam, but I'm actually required to go to the masjid for whatever prayers I can. So I would take him with me. He would sit against the wall, play on his Kindle or whatever he likes to do while I pray. Are you telling me that that would be a violation of the court's orders, and then what would happen?
Mr. Roman, I don't know how to answer your question because I don't answer that. But you could think about
going to go practice my religion. My son will probably be with me.
Is what you expressed to the court before the litigation.
Up until now, I've followed the court's orders, but now the court is ordering me not to practice my religion.
You're absolutely wrong on that.
Okay.
Didn't say that at all.
We'll see.
What's that mean? Threatening you, sir? Is that a threat?
Are you serious?
Are you?
No, I said, we'll see. It's a hypothetical, sir. I don't
want you to explain yourself, because I just heard you say to me something that sounded threatening to me based on context.
That's dishonest. What I said was, we will see what happens if I were to take my son to the masjid with me. And what I'm saying is that you are forbidding the free practice of religion, which is unconstitutional, so that's probably going to be something we see about, isn't it?
So, Mr. Norman, I didn't say that. You just now twice told me that I said that.
Can I go to the masjid?
And I did not say it.
May I practice my religion?
You can practice any religion you want.
When I have my son.
When you've complied with the court orders.
I'd really like to stay out of jail. May I practice my religion when I have my son?
Mr. Norman, you can comply with all the court orders. Anything else?
My understanding is the court's ordered me not to practice my religion when I have my son.
I don't know how you read the court orders, Mr. Norman. I'm really at a loss as to what your thinking process is.
No, you're not.
Judge Roberts stated his belief that a child merely observing a religious ceremony, such as prayer in a mosque, constitutes participation in that ceremony. However, the act of prayer in a mosque is identical to prayer conducted at home or any other location. Therefore, by Judge Roberts' reasoning, any instance of a child witnessing their parent praying equates to the child's participation in the prayer. The only logical interpretation of Judge Roberts' position is that Mr. Norman was prohibited from praying in any setting where his son might see or hear him. Given these circumstances, Mr. Norman repeatedly sought clarification of the court's order, both during this hearing and in subsequent hearings. These requests were ignored, and Judge Roberts refused to clarify the scope of his orders, leaving Mr. Norman to navigate an ambiguous and unconstitutional restriction on his fundamental rights. In remarriage and murder, the California Court of Appeals stated that courts cannot limit a parent's religious practices or teachings unless there is clear evidence that such practices harm the child's welfare. Without evidence of actual harm, any restriction on religious practice violates the First Amendment and similar protections under the California Constitution. In Wisconsin versus Yoder from 1972, the U.S. Supreme Court held that laws interfering with religious practices must pass strict scrutiny. This means the government must show a compelling interest and that the restriction uses the least restrictive means to achieve that interest. Judge Timothy P. Roberts must have known his order was illegal when he issued it. After all, California courts have been required to demonstrate actual harm before imposing restrictions on religious practices since 1980. The situation highlights a dangerous reality. Family courts are wielding unchecked power to arbitrarily violate fundamental rights without accountability for their illegal and abusive orders.
I'm standing with the resolution and that we should take action today rather than postponing this.